Thank you for the opportunity to speak on the topic of prosecutor and prosecutorial discretion. As a researcher in the field of criminal justice and criminal procedure, I have studied the role and impact of prosecutor and the use of prosecutorial discretion. Prosecutorial discretion is a crucial aspect of the criminal justice system as it allows prosecutors to make decisions about whether or not to bring charge, the severity of charge, and the negotiation of plea bargaining deals. The exercise of prosecutorial discretion can also lead to concern about fairness, consistency, and bias. In my talk today, I will talk about the fundamental role of prosecutor and share my research on the use of prosecutorial discretion and its application in Taiwan criminal justice system. The prosecutor is a key player in the criminal justice system as the representative of state. The prosecutor has a duty to seek justice and protect the public interest. However, prosecutors also have significant discretion in deciding whether to bring charge against a suspect, what crime to bring, and whether to offer plea bargain or other agreement. Prosecutorial discretion refers to a power of prosecutor to make decisions about how to handle criminal cases. This includes decisions about whether or not to charge someone with a crime, what charge to bring, and whether or not to offer plea bargain or other agreement. First, let us think about the legal status of prosecutor. The separation of power is a fundamental principle in modern democracy system of government that is designed to prevent any one branch or individual from gaining too much power and potential abusing it. It involves the division of the government authority into three separate branches: the legislative branches, the executive branches, and the judicial branch. The prosecutor's role is typically considered to fall under judicial branches of government in the separation of the power. Because prosecutors are responsible for enforcing the law and bringing cases to court on behalf of the government, they work alongside judge and other members of the legal system to ensure that justice is served. However, it's worth noting that the precise role of prosecutor can vary somewhat depending on country and legal system in question. In some cases, they may be considered to fall under the administrative branch of government, particularly if they are responsible for managing or overseeing other aspects of law enforcement. Overall, the prosecutor's role is primarily focusing on the judicial branch function of government, and they play a critical role in upholding the rule of law and ensuring that criminal activity is properly investigated and prosecuted. Next, let us take a look about how Taiwan and the United States prosecutors are appointed. In Taiwan, public prosecutors are considered civil servants and are subject to the same appointment requirement as judges. They must pass the National Judicial Exam, which is a three-stage examination system, to become licensed as prosecutor or judge. After passing the judicial exam, the examinee will become intern judge or intern prosecutor. They must undergo a 2-year training program at the Judicial Training Academy. Once they complete all the licensing requirements, they can choose to become a prosecutor or a judge. This rigorous process ensures that prosecutors in Taiwan are highly qualified and well-trained professionals who are dedicated to upholding the rule of law and protecting the rights of citizens. The United States is unique that it allows citizens to elect their prosecutor only at the state level. The federal prosecutors are still appointed by the president. This serves two important purposes. First is to remove prosecutors from political patronage, which means that they are not appointed by politicians with partisan interests. Second, it allows democracy accountability, since a citizen can hold prosecutor accountable for their action by voting them out of office. By allowing citizens to elect prosecutor, the United States ensures that prosecutors are accountable to the people they serve rather than to potential interests or special interest groups. This helps to promote fairness, impartialness, and the rule of law, and ensure that prosecutors are focusing on protecting the rights and interests of citizens rather than advancing their own agenda. There are several explanations for why the United States moved toward electing prosecutors in early 19th century. One of these reasons is that citizens did not trust the executive branch to make fair and impartial appointments. By allowing the citizens to elect their prosecutor, they could ensure that prosecutors were accountable to the people they serve and not to the political interests. Another reason is that prosecutors become more important as the public prosecution system gains prominence in the country. As prosecutors' roles and responsibility grew, so did their discretional power. By electing prosecutors, citizens could ensure that those with the greatest responsibility for enforcing the law were held accountable to the people they serve. Overall, these factors contribute to the development of the electoral system for prosecution in the United States, which remain in place today as a way to ensure that prosecutors are independent, impartial, and accountable to the people they serve. There are two main purposes of prosecutor election in the United States. The first is to isolate the justice system from political pressure. The second purpose of prosecutor election is to ensure the prosecutorial discretion reflects societal need. Overall, prosecutor elections serve as a way to ensure that prosecutors are accountable to the people they serve rather than the political interests or special interests. There are criticisms of prosecutor election system in the United States. First, there is a lack of competition in many elections. Statistics shows that the incumbent prosecutor is 95% win ratio and 84% of prosecutors run unopposed. This lack of competition can lead to a lack of accountability, a lack of choice for voters. Second, election can encourage more conviction and tough on crime policy. According to data, the number of convictions increased in the year before the election. However, this can also lead to the more errors in prosecution, while may require the invention of appellate court. For example, in assault case, 72.7% of convictions were upheld with the reflection and 85.4% without the re-election. These criticisms highlight some of potential issues with the prosecutor election system in the United States. While elections still promote accountability and reflect societal needs, they can also lead to unintended consequences and undermine the fairness of justice system. Next, we will move on to the next part, the prosecutor discretion. The legality principle in Taiwan refers to mandatory prosecution system as outlined in Article 251 of Code of Criminal Procedure. Under the principle, if a public prosecutor has sufficient evidence to show that an individual is suspect of having committed an offense, a public prosecution must initiate regardless of the location of the accused. This principle reflects that the idea that no one is above the law, and that criminal proceedings should be initiated against anyone who is suspect of committing of a crime, regardless of their social status or other circumstances. By requiring mandatory prosecution, the legality principle ensures that the justice system is fair and impartial, and that all individuals are held accountable for their action. On the other side, the discretional prosecution system in Taiwan is a legal principle that allows prosecutors to use their discretion in deciding whether or not to initiate a public prosecution against an accused individual. Under this system, if an accused has committed an offense other than those punishable with death penalty, death penalty, life imprisonment, or with a minimum punishment of imprisonment for not less than 3 years, the public prosecutor can choose to defer prosecution for a period not more than 3 years and not less than 1 year based on consideration outlined in Article 57 of the Criminal Code and the maintenance and protection of public interest. This system gives prosecutors the ability to consider the specific circumstance of a case and the potential impact of a criminal trial on the accused and the broader community before making a decision on whether to pursue prosecution. By allowing for discretional prosecution system, prioritize the efficient use of resources and ensure that justice is served in a fair and appropriate manner. Taiwanese prosecutors have several options when deciding whether to initiate a public prosecution against an accused individual. Article 251 of Taiwan Code of Criminal Procedure mandates that if the evidence obtained by a public prosecutor during the investigation is sufficient to show that an accused is a suspect or committing of offense, a public prosecutor should initiate. However, prosecutors also have the discretion to use non-prosecutorial disposition under Article 252 and 253, which involve alternative to traditional criminal trials such as fine or community service. Deferred prosecution is another option available to prosecutors under Article 253-1, which allows them to defer prosecution for up to 3 years based on consideration outlined in Article 57 of Criminal Code and maintaining and protection of public interest. Finally, the plea bargaining option under Article 455-2 allows prosecutors to negotiate with the accused to each a plea bargaining which may involve reduced charge and penalty in exchange for a guilty plea. These options allow prosecutors to consider the specific circumstance, each case, and choose the most appropriate course of action rather than being required to pursue prosecution in every case where guilty is suspected. Suppose the victim is dissatisfied with the prosecutor's non-charge decision. The victim still has a repeal of the deferred prosecution process. In Taiwan, victim has the option to request a reconsideration of the prosecution decision through a two-stage review process. The first stage is involve an internal review by the prosecutor's office, where the victim can directly apply in writing with 10 days of receiving a non-prosecution disposition. The complaint is then sent to the original prosecutor who made the decision for reconsideration. This process provides an opportunity for victim to challenge the prosecutor's decision and potentially reverses. The external supervision system for two-stage review in Taiwan involves a formal trial, which is initiated by the victim after failing to obtain reconsideration of the prosecutor's decision through his interest review process. To ensure this option, the victim must hire an attorney to make the application. The formal trial allows the judicial review and external supervision of the prosecutor's decision. The judge can review the evidence, the legality of the prosecutor's decision, and whether the decision was made in good faith. This two-stage review process involves an additional level of oversight and accountability for prosecutors in Taiwan. In conclusion, the Taiwanese criminal justice system allows victims to directly pursue justice and regain control over the prosecution decision. This is achieved through various mechanisms such as the prosecutor discretion power, the internal prosecutorial review process, and external judicial supervision. By connecting the prosecutor charging guideline with secular perspective and common sense, victims have the power to check the prosecutor's decision and ensure that justice is served. Overall, these features of the Taiwanese criminal justice system provide a fair and transparent process for victims to seek justice. Thank you for listening to my presentation on the topic of the role of prosecutor and prosecutorial discretion. I hope that I have able to provide you with some insight of the prosecutor and prosecutorial discretion. Thank you once again for your attention.